Welcome, everybody, to today's Law of Self-Defense show. Unscheduled, or at least as of yesterday, I hadn't planned to do a show today, but here we are. And the reason we're here is because earlier this week, I was discussing, reading the U.S. District Court trial court decision out of California, Duncan v. Bonta, in which that trial judge, Benitez, had found for a second time that California's standard capacity magazine ban was unconstitutional. And so Californians were going to be permitted to purchase standard capacity magazines for the first time in 20 years. Purchase, possess, borrow, all those things. Unless, of course, the Ninth Circuit, which is the appellate circuit that oversees this district court, disagreed with the trial judge, as they had done before. So the previous history of this is that this same judge had previously ruled the California's standard capacity magazine ban to be unconstitutional. The state appealed that to the next level in the judicial process, which is a 3-judge appellate court panel, and they agreed. And then the Ninth Circuit does what it often does in these Second Amendment decisions when they get a bad ruling from a trial judge and a bad ruling from a 3-judge appellate panel. They decide to take it en banc. En banc is when they get to put together a larger group of mid-level appellate court judges, in this case 11, because overall, the Ninth Circuit is a liberal circuit, the most overturned circuit of all the federal appellate court circuits, by a large margin, and they have a deep-seated hatred for the Second Amendment. So when a trial judge unusually gives a Second Amendment favorable ruling at the trial level, and then that's appealed, and the 3-judge appellate court sustains that Second Amendment favorite ruling, standard procedure for the Ninth Circuit has been to go en banc, get that larger 11-judge panel to reverse everybody else and sustain the Second Amendment infringing law. And that's what they did. In the previous Duncan case, was heard at the trial level. Magazine ban is unconstitutional, said the trial judge. Heard by a 3-judge panel, appellate court. Magazine ban is unconstitutional. Goes en banc. The Ninth Circuit takes it en banc, and guess what? They sustain the magazine ban. So this goes up to the Supreme Court, and the Supreme Court decides separately Bruin. And Bruin says that an infringement of the Second Amendment is presumptively unconstitutional in the absence of the state being able to clearly show that there's a history and tradition of that kind of infringement that would have been accepted by the founders, the time of the founders, or the time immediately after the Civil War, when the 13th, 14th, 15th Amendments extended the Bill of Rights to restrict the authority of the states and not just the federal government. What was the understanding of the Second Amendment, and what were acceptable restrictions of the Second Amendment at those time periods? Can you show us history and tradition? So after Bruin, the U.S. Supreme Court said, hey, this Duncan case, we're going to send that back to the trial court and have him do a reanalysis of it under Bruin. The state, California, can argue if they believe there's a history and tradition of standard capacity magazine bans. And so it was reheard at the trial level, and the state made their arguments. And Judge Benitez, having heard these arguments, issued a 71-page decision in which he guts the state's arguments one after another after another. And earlier this week, I spent 2 entire shows, a couple of hours, 2.5 hours of time reading through and discussing Judge Benitez's second finding of California standard capacity magazine ban to be unconstitutional. So, of course, he's just a trial judge, right? So what would be the normal procedure for California to follow if they don't like their standard capacity magazine ban being found unconstitutional? And of course, they don't like it. They hate it. They hate it. So they don't like the trial judge's decision. They asked them for, hey, don't make the law invalid immediately. Give us a stay of your ruling for a few days so we can prepare our appeal. Because if we went on appeal, then we wouldn't have wanted all these, because large capacity magazines, if the law is found invalid and it's not stayed, will flood into California maybe by the millions. 20 years they haven't been able to buy standard capacity magazines. It'll be the biggest sucking sound you've ever seen come out of California, as every standard capacity magazine in inventory anywhere in the US just gets sucked up by California. There'll be gun owners waiting with their finger on the order button the minute they're lawfully permitted to order those magazines. Now, the stay suspending the unconstitutionality of this magazine capacity ban was going to end on Monday, October 2nd. California, of course, wants to appeal. So the normal procedure would be for California to appeal Judge Benitez's ruling to a 3-judge appellate court panel. But the state doesn't want to do that, because the last time they did that, Judge Benitez's conclusion that the ban was unconstitutional was upheld. And they had to go en banc to get that reversed. So what did they decide to do? Go straight en banc with the support of the Ninth Circuit, some of the Ninth Circuit. Because one of the things we learned when the Ninth Circuit announced they were skipping the 3-judge panel, they were skipping their normal procedure and just going straight to en banc, was that this was a backroom deal by just the most hateful of the Second Amendment judges on the Ninth Circuit. They violated their own rules and procedures in order to go directly en banc. So, those of us in favor of the Second Amendment, watching how the Ninth has typically operated in Second Amendment law, we always kind of suspected that, well, they have a deep emotional hatred of the Second Amendment. So, of course, why wouldn't they bend the rules? Now, we had no evidence of them bending the rules, so it felt kind of like a conspiracy theory. But we have evidence now. And this was all really brought to my attention. Make sure I'm streaming everywhere I need to be streaming. I'm very excited about this. And I don't have a lot of time. I have some actual lawyer stuff I need to take care of today. So let me just do this quickly. I really have only until the half point of the hour, folks, to cover all this. So I just want to make sure this is working. So this was brought to my attention by attorney Costas Moros. Costas has been on the show before, very recently, within the last couple of weeks, and very, very smart guy. The firm for which he works, Michael and Associates, Chuck Michael, this is a California law firm. Chuck Michael, the senior partner of that firm, has been a strong Second Amendment advocate fighting these legal battles for many, many, many years. I met Chuck, who knows, 8 or 10 years ago at one of the NRA annual meetings. Very nice guy. And recently, Costas got brought to my attention because of his work on Twitter. And so we connected. He was a guest on the show to talk about what was happening in New Mexico at the time, with the governor there trying to suspend the Second Amendment in a couple of the major counties. Very smart guy. So I considered inviting him on this show, except I know his firm is participating in this litigation. And he indicated to me he wouldn't have been able to come on anyway for that reason. But so, as you imagine, the firm's participating. He's following this very closely. And he had this tweet: the Ninth Circuit en banc panel is taking back Duncan. Duncan is this whole series of court decisions as a comeback case. So skipping the 3-judge panel that would normally get this case at this point. And the stay is extended from October 2nd to October 10th. Our opposition is due September 30th, which is, of course, tomorrow, Saturday. So that window we were going to have where Californians could start buying standard capacity magazines on October 2nd, that's gone now. So it's been extended to October 10th. Probably will be extended past then if it needs to be. Costas writes, bad news is that's a tough 11-judge panel for us. Good news is back to SCOTUS much quicker. So I really would love to have Costas on here to talk about this. But one of the issues here, so it's kind of a best of times, worst of times kind of thing. So it's not really the proper procedure for this to go directly en banc. And it does mean that there probably will not be a freedom window of time for Californians to buy standard capacity magazines, like occurred last time the Ninth Circuit pulled these shenanigans, because they're going en banc, and the en banc will certainly affirm the purported constitutionality of the ban. But because they're going en banc, the path to get this issue to the U.S. Supreme Court is much shorter than it would be if the Ninth Circuit had followed standard procedure. Because if there had been just a straight appeal to a 3-judge panel, that takes a certain amount of time. Then they have to decide to do it en banc. That takes a certain amount of time. So the path to the Supreme Court to address this issue would be much longer if standard procedure had been followed. So we're not getting the benefit of standard procedure. We're not getting the freedom window to buy the standard capacity magazines in California, but we are getting a quicker path to the Supreme Court. Then let's see, I saw this other tweet from Costas. He just posted up the decision, the announcement by the Ninth Circuit that they're taking it en banc. So that's where I got the document we'll be going through in a couple of moments. And then he wrote this, having read the announcement by the Ninth Circuit, because the Ninth Circuit's announcement that they're taking the case en banc was very short. It's about a page long and one concurrence about another page. But then there's several pages of dissents. And the dissents are hot, and they expose some of the backroom shenanigans the Ninth Circuit has been pulling on this Second Amendment case and presumably other Second Amendment cases. And let's see, I think Costas notes, he says here, I've always doubted the conspiracy theories that these kinds of backroom deals were being done within the Ninth Circuit on the Second Amendment, because I figured the few conservatives in the Ninth Circuit would have said something. Well, now one of them is, in his dissent to this announcement by the Ninth Circuit that they're just going straight en banc. By the way, I couldn't find the tweet on short notice, but Costas had another tweet where he said, listen, given that the Ninth Circuit is engaged in these kind of backroom shenanigans, this is something that the U.S. Supreme Court should take notice of when they're reviewing Second Amendment decisions out of the Ninth Circuit. That they're not just applying legal reasoning in the normal course of justice, they're cutting backroom deals, specifically targeting the Second Amendment. U.S. Supreme Court, the court that just issued Bruin, they should take notice of that. All right, so let's jump into the actual announcement. It's not very short. It's not very long, fortunately. So it's Duncan v. Bonta. Of course, that's the case before, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. This is 11. This is the en banc panel. And here's the announcement by the majority of that panel. Appellant Attorney General Rob Bonta has moved to stay the district court's permanent injunction of the standard capacity magazine ban. Let's see. This emergency motion by the state seeks relief on or before October 2nd, Monday, when the temporary stay would have vacated, when the district court stay of the injunction expires. In the event the court cannot resolve the motion by October 2nd, appellant, the state of California, seeks a temporary administrative stay. The en banc panel for the Ninth Circuit says the motion for a temporary administrative stay is granted. The injunction issued by the district court is stayed through October 10th. The stay does not apply to the district's blah, 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 blah. This is really just for new purchases of magazines at this point. Appellees are directed to file a response to the emergency motion on or before Saturday, September 30th. This is Costas and his group. Appellant may file a reply on or before Tuesday, October 3rd. So California may file a reply to the plaintiffs, the appellees' own response by that date. Judges Ikuta, Nelson, Bumate and Van Dyke dissent from the granting of the administrative stay. Now, there is a concurrence here because the dissent is super hot under the collar about this. And the concurrence is really ridiculous because we have to pretend we don't know what this en banc panel is going to do. We have to pretend that they're simply applying law in the normal process of justice. We have to pretend that they're not in existence purely to simply pretend that this standard capacity magazine ban is constitutional. Circuit Judge Hurwitz writes, the only thing the court does today is grant a 1-week administrative stay that effectively extends the stay ordered by the trial judge while we take up the state's emergency motion for a stay pending appeal. It's no big deal, folks. We're just extending what the trial judge did for another week. That's all. We're not going to shaft the Second Amendment in this process. No, you can trust us. We're not like the other en banc panels of the Ninth Circuit on the Second Amendment. We're going to be fair. He continues, despite the rhetoric from my dissenting colleagues, this temporary stay evinces no more disrespect for the Supreme Court or the Second Amendment than does the trial judge's stay. I therefore concur in the order granting the stay. Now we have the first dissent. And the dissents are hot. Bumate, judge dissenting. For over a decade, our court has improperly interest-balanced our way around the Second Amendment. The Supreme Court has had enough of it. See New York State Rifle and Pistol Association v. Bruin. In Bruin, the Supreme Court made clear that the Second Amendment must no longer be deemed a disfavored right. With this clear direction from the Supreme Court, you might think that our court would return to regular order and handle the Second Amendment case like all others before our court. And in the normal course, emergency motions would be handled by a 3-judge panel. But not here. Because this is a Second Amendment case, we now take the unprecedented step of taking an emergency motion as an en banc panel in the first instance. While our rules may leave room for such an unusual step, discretion and wisdom counsel against it. Indeed, to my knowledge, no en banc panel of this court has ever handled an emergency administrative stay motion as an initial matter. And the majority cites no precedent otherwise. So I'm left wondering why we rush to do something so unorthodox. I thus respectfully dissent from the grant of the administrative stay. Such a decision should be left to the sound judgment of a 3-judge panel. And if you thought that was hot, Judge Van Dyke brings the heat. Here he is. I share Judge Bumate's concerns about the irregularities created by this en banc panel's all too predictable haste to again rule against the Second Amendment. Apparently, even summary reversal by the Supreme Court has not tempered the majority's zeal to grab this case as a comeback, stay the trial court's decision, and make sure they, the en banc panel, not the original 3-judge panel, get to decide the emergency motion and ultimately the eventual merits questions in favor of the government. I think it is clear enough to everyone that a majority of this en banc panel will relinquish control of this case only when it is pried from its cold, dead fingers. And I think it is clear enough to everyone why. There is a phenomenon that long has been recognized in abortion cases, sometimes called abortion distortion, that describes courts' willingness to jettison procedural norms or other normal rules of decision-making when a case concerns abortion. As the Supreme Court recently observed in Dobbs, abortion cases have led to a distortion in legal doctrines ranging from severability to First Amendment doctrine. And Justice Clarence Thomas has likewise decried the troubling tendency to bend the rules when any effort to limit abortion or even to speak in opposition to abortion is at issue. He's got a lot of quotes here. Hold on. Got to find my place. He continues, Judge Van Dyke. Cases involving the Second Amendment in our circuit, the Ninth Circuit, have unfortunately suffered from a like phenomenon. And just as we should no longer distort our rules in abortion cases, we should no longer apply different rules to different constitutional rights. We should not give Second Amendment cases special treatment. But the current irregularities highlighted by Judge Benitez's dissent are not the only way this case continues to demonstrate our court's enduring bellicosity toward the Second Amendment. The irregularities in this case run much deeper. Indeed, all the way back to when this case was first called en banc. This en banc panel, because it's the same 11-judge panel as the last time, folks, this en banc panel was born in illegitimacy, and this case should never have been taken en banc in the first place. After the 3-judge panel first issued its opinion in August 2020, concurring with trial Judge Benitez that the standard capacity magazine ban in California was unconstitutional, after the 3-judge panel first issued its opinion in August 2020, one judge on our court requested a Rule 5.4b notice in 3 cases, including this one, but then inadvertently missed the deadlines to timely call the cases en banc under our clear rules. Now, this could happen to any judge, right? Mistakes happen. But rather than simply accepting the result dictated by our rules, that the finding of unconstitutionality of the magazine ban remains on the books, but rather than simply accepting the result dictated by our rules, or even deciding as an entire court to waive our rules, which they can do, we went in a different direction. First, the decision was made by someone, not by the rules or even the entire court, to allow the respective panels to waive the deadlines on behalf of the entire court. Then the campaign started. Earnest conversations were had, hearts were poured out, tears were shed, and pressure was applied to the panels with mace-like collegiality. And in the end, a discrete collection of judges, again, not the entire court, as the rules require, struck a compromise, circumvented our own rules, and allowed the en banc call to move forward. But only in this one case. The agreement was made to call this case, but drop the en banc calls in 2 other cases, including a death penalty case. Priorities. A lot about this is troubling. First and foremost, we have rules for a reason. We operate under them every day. They should apply equally and consistently, unless and until we change those rules in the normal course. There is no exception for cases that some of the judges on our court really care about. That would be capricious and erode external and internal confidence in our court. If we lack the temerity to codify a Second Amendment exception in our en banc rules, we should have refrained from employing it behind the double veil of internal court matters in which only some members of the court participated. Second, because we have clear, settled, court-wide rules, a discrete group of panel and off-panel judges interested in en banc rehearing shouldn't have been permitted to circumvent those rules on their own. We have a process for suspending the rules upon a vote of the entire court. But no judge tendered a request for that process. Instead, this was handled off the books by a handful of judges, which makes it even worse. This off-books approach allowed the would-be en banc advocates to pressure the panels to be collegial, and simultaneously concealed these conversations from the rest of the court. It also delimited the scope of the question to whether we would bend the rules and allow some exceptions in 3 specific cases, which prevented the entire court from considering the weightier question of whether, as an institution, we should be suspending our settled rules for particularly important cases. Such agreement, however procured, does not somehow confer legitimacy. In sum, not only is our court treating this case special now, but the process that brought this case en banc in the first place was illegitimate from the start. This demonstrates and perpetuates this court's, the Ninth Circuit's, anti-Second Amendment posture, rewards the weaponization of one-sided collegiality, and damages the internal and external integrity of the court. How are we to uphold the rule of law and reassure the public we are doing so when we disregard our own rules and make questionable decisions like this behind closed doors? The story of the Second Amendment in this circuit has been a consistent tale of our court versus the Supreme Court and the Constitution. That tale continues today and will continue as long as a number of my colleagues retain the discretion to twist the law and procedure to reach their desired conclusion. As uncomfortable as it is to keep pointing that out, it is important the public keeps being reminded of that fact. Bam! Judge Van Dyke bringing the heat. Thank you, you patriot. Thank you. All right, folks. So the California ban remains in effect. Surely the en banc panel will decide, using its normal word salad approach to legal reasoning, that it's perfectly fine for California to retain this standard capacity magazine ban, that it's not unconstitutional, regardless of the 70-page decision we just read through this week from Judge Benitez, because that's what Ninth Circuit en banc panels do with Second Amendment law. It's always okay for the state to have whatever infringement it wants. And we'll have to see this go on to the Supreme Court. Now, the good part of that is presumably the Supreme Court that wrote Bruen will concur with the trial judge's analysis under Bruen and Heller and McDonald and Cateno, all the major U.S. Supreme Court decisions on the Second Amendment in the last 20 years. And the Supreme Court will come to the conclusion that these standard capacity magazine bans are unconstitutional. And if they do it, then it's not just California that loses the ban, it's everywhere, including my home state of Colorado, which has a 15-round magazine capacity ban. So there we are, folks. All right, I've got some actual lawyer stuff to do in about 2.5 minutes. So I'm going to wrap up this show here. Hope you enjoyed that. In the description of today's show, I have the links to this order, to Judge Benitez's order, to our readings of Benitez's order earlier this week, and to the interview we did with Costas a couple of weeks ago on the New Mexico thing, so you can get exposed to him. By the way, this is his Twitter, at Moros Costas, MOROSKOSTAS. He's great on the Second Amendment stuff, folks, so I strongly encourage you to give him a follow over on Twitter. All right, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until probably Monday, we've got definitely have a show scheduled for Monday. Until Monday, when I see you all again, stay safe. Have a good weekend.